Welcome everyone to Australian Business Lawyers and Advisors Workplace Investigations Tips and Tricks webcast for today. My name is Joe Murphy and I am the National Workplace Managing Director, and with me today is Julian Art, who is our Sydney-based Associate Director. Today we're going to talk about investigations, tips and tricks. Jules?
It's an absolute pleasure to be here today, Joe. On the agenda today we're going to do a number of things, but what's really pleasing about today is we've got a whole range of people tuned in, and what we're talking about, workplace investigations, it really is the bread and butter of the HR practitioner's skill set. We're going to go through a lot of basics today, but hopefully we're going to give you some insights and some tips and tricks about perhaps where HR practitioners and we all go wrong in terms of investigations and hopefully how to avoid those.
Yeah, definitely. Looking at our agenda today, we're going to talk about some preliminary questions because they are all important in not getting it wrong. Kicking off your investigation, we're going to talk about how you come to a landing on findings and reasons. We're then going to talk about managing your reputation a bit, and Julian's had some challenging, interesting matters very recently that he can talk about, not in any detail, but in the general sense. And then we're going to talk on some frequently asked questions that we get as well, which I think will help. We've also got our little iPad here today, which questions come throughout the day. We do have our trusty assistant, Fiona, who's here to flag us when there's a really good question, but we will make our way through the questions later on if there are any questions to be asked. Now, I hope there are. There usually are. But moving into our first phase of preliminary questions, and this is where organisations tend to get it really wrong, misjudging how to go about conducting an investigation and whether or not you should conduct one at all. So the first thing we normally ask ourselves is, well, how serious, really serious is the conduct? You can't come to a final landing about that from the outset, but you can get a sense for it. You can get a sense for it right at the beginning. How serious is this conduct? If it's not serious conduct at all, then you need to think of a way to manage that, and it may not be through a really formal investigation. Are there any interim measures that you need to put in place immediately? Are there any employees or other individuals in the workplace that are at risk? You're not just thinking about the complainant, you're thinking about other witnesses, you're thinking about, and sometimes you're thinking about the accused as well. In the work health and safety sense, your obligation is to ensure the health and safety of all of those people, not just the person making the allegations, but also others involved, including the accused. So it's really important that you consider whether or not there are any safety arrangements that need to be put in place, any controls that need to be put in place. You've also got to be really careful not to put in place arrangements that look like you're victimising the complainant at the same time. So you really need to conduct a preliminary assessment of the circumstances at that point in time.
It's a fine balance, Joe, because generally, particularly if it's a serious complaint, a complainant will not make a serious complaint lightly. Once that complaint has been made, as Joe says, it's imperative that your health and safety obligations are complied with to make sure that whatever danger could be arising out of the complaint or the alleged conduct, that you can neutralise it and conduct your investigation in a balanced and I guess a safe way. The other question which we get routinely is, well, do we suspend this person? We've had an allegation against someone, we're very concerned about it. Do we suspend them? Often the question is, can we suspend without pay? Joe, what would be your answer to that?
Well, look, we generally caution against without pay. It's very rare that you'd be able to suspend without pay. We always get the question, so we always give it consideration. Historically speaking, if I think back over the 20 years that I've been doing this, there's probably been a small number of occasions where we have suspended without pay. Some discrete public sector arrangements that provided for individuals who could be suspended without pay, and some very, very serious conduct that was prima facie able to be proven right there and then, and it was a question of finalising or at least going through some investigative steps to get to the point where you could make a final conclusion about the conduct and what you were going to do. But it's very rare you would suspend without pay, very rare. And that's why it's really important when you're talking about suspending that you scope the investigation properly at the front end, because if you are going to suspend someone, don't forget you've got someone sitting out there on pay.
We'll get to delay later in the presentation about how quickly you can actually do this investigation, but Joe's exactly right. Once someone is suspended, paid or unpaid, they are sitting outside the workplace, and to the longer that they stay there, I guess the more difficult it is for things to resolve in a seamless and easy way. The other really good question to ask at the start in terms of suspension is, if the allegation is of a seriousness which maybe you might get to the end of the investigation and determine that, well, this is serious misconduct and it warrants summary dismissal. If you haven't suspended the employee for the period of the investigation, let's say it's a safety breach, and you've left that employee work on the line, or work in the truck, or work in the workplace with someone for that period of the investigation, whether it be a couple of days, a couple of weeks, or maybe a month, the question will be asked of you at the end of it, well, was it that serious? Was it really serious misconduct because you've let this person work for the entirety of the investigation without suspending them? You couldn't have thought it was that serious, and that brings with it a problem.
Yeah, and of course there is a legal position that the industrial tribunals will take and have taken historically, and that a delay will give rise to that question. And the question is not just if it is serious, but the delay itself can suggest that it mitigates against the seriousness of the conduct, regardless of what your opinion is about how serious the conduct is. So it's almost condonation of the conduct to a degree. Now, you've also got to conduct, you also have to conduct an assessment of the mechanisms that you've got in place, if any. If you don't have any mechanisms in place, then it's really important that you put some in place so that you can conduct an investigation. And before you choose who's going to investigate, or at the time you choose who's going to investigate, you need to do that assessment. Do we have a policy in place? Do we have any other documents that need to be filled out? Do we have a suite of letters and correspondence and guidelines that will help manage the witnesses and the risk around an investigation? So you do get to that point where you have done that assessment and you know what's in place, or you know what you need. If you know what you need, it's a question of going to get it.
That's right, Joe. Well, the other thing you really need to put yourself in the place of the investigator at the end of the process, once everything's done and when they get to writing a report and putting pen to paper. You want to know that there's a policy from the outset. You want to know the rule that you're trying to assess whether it's been broken. You want to know the obligation that you're trying to assess whether it has been complied with or not. Essentially, it's a classic case, but preparation is key with investigations, and you really need to front end everything to make sure that the process runs smoothly and you get to somewhere where it's defensible at the end.
Yeah, look, absolutely. But before we quite get to that point, we need to find out who's going to investigate.
Absolutely.
And so one of the things that organisations do, and we understand that organisations can't afford to be spending great swathes of money on external investigators, whether they be lawyers or not lawyers, expert investigators. It is really important that organisations are able to consider, where they've got the size, whether or not someone internally can do that investigation. And look, in many circumstances, it's actually desirable that a person who is internal does the investigation. In other circumstances, it's not so desirable. But what's really important is that the person has the capability to do the investigation. They ideally are not someone who has no experience and no training around investigations. It's really important that the person is as independent as they can be. Now, you might say, well, as a person who's being investigated, how can the internal HR coordinator or business partner or HR director or manager or the relevant line manager be independent? And it's important you do that assessment and ask the question, why is this person raising a concern, or why might they raise a concern about that person's independence? Now, if it's just, hey, they work for you, well, that generally doesn't suggest that they're not independent. It is accepted by the industrial tribunals, the Fair Work Commission in particular, and acknowledge that organisations will need to be able to conduct investigations internally, and that there is enough independence around someone who is within the organisation, within the company, to be able to conduct that investigation. So you need not go external all the time.
Joe, that's absolutely right. Not every complaint is going to warrant calling the lawyers in. It's not a particularly useful way to run a business, both in cost-wise, but also if every decision and if every allegation needs to be resolved by an external party, we're probably not doing the things that we need to be doing in running our business and managing our staff. What I always find interesting, and Joe touched on it just before, is that investigators need to be independent, absolutely need to be independent. But I think equally critically is they also need to be seen to be independent. So selection of the investigator is really important. We might have absolute trust that the person that we choose, whether they are internal or maybe they are even external, are completely independent, unbiased, and are going to do a great job. If the complainant or the person who has allegations against them doesn't share that view from the get-go and they have a reasonable suspicion that, well, this is actually a stitch-up or this isn't being taken seriously, that the purpose of the investigation is not going to come to fruition. Be independent, but also to be seen to be independent, and that's a judgment call from the start.
It is, and it's important not to jump at shadows. So it's a balancing act, because if you do find that an individual makes a complaint about the investigator not being independent, you're then turning your mind to whether or not you need to find someone else to do it. And it can be a chain reaction or a domino effect where the individual just says, look, I just don't trust anyone in the organisation. And then you do need to consider whether or not going external is something you should do. There is a point in time at which you do dig in, but you really want to make sure that you've got clean hands at that point in time, and that it's not just as I say, they need to be independent, but they're seen to be independent, as Julian says. Now, the other really important thing if you're using internal people is making sure that person has the right support and the resourcing to actually conduct an investigation. If they don't have the right support and resourcing, often these people actually have day jobs and their job is not as an investigator. I know I've worked with many government agencies who have had investigation units, and it is their job to do it, but mostly organisations who have HR teams, part of their job is to conduct investigations, but look, it is not their full-time job. And some of these investigations can become very involved and very time-consuming, and they find it quite challenging. Now, that in itself can result in the investigation being compromised. And I have seen investigations where they are time-consuming, complex, require additional effort, because the reality is that a full investigation requires a significant amount of effort, and that's why they're costly when they go external. So it's really important, support and resourcing.
I could see a lot of people nodding onto their webcam cameras. This is something that I always find, to the extent that I've personally done investigations, it becomes a serious block of time that you need to devote to interviewing a lot of people, coming to conclusions about things, writing a report. Internal resourcing often, as Joe says quite rightly, that there are other things going on in the business apart from your investigation. So if you're not going to have time to do this, it's very worth investigating whether you need an external investigator.
And some of the factors that go into that, additional factors, are the complexity of the allegations. There might involve criminal allegations as well. It might involve someone very senior in the organisation, and that does create sometimes an insurmountable perception of bias or conflict for the investigator. The investigator should never report up into someone against who an allegation is made. That can be disastrous, and it can suggest that there is a genuine perception of bias or conflict for that person actually conducting the investigation. And then you also consider whether or not legal professional privilege is something that you require, because if the organisation has significant potential legal risk around the issues, then we often get clients that come to us and say, look, we've got this legal problem, and we say to them, we need to do an investigation to find out exactly, or we need an investigation done, whether we do it or someone else does it, in order to find out what the facts and circumstances are, so that we can assess the legal risks and provide you with legal advice. Of course, for legal professional privilege to apply, it needs to be, the investigation needs for the dominant purpose of the lawyer providing the legal advice. Planning the investigation. So the first thing you want to do is make sure that you've got clarity of complaint. So you really want to know, do you have enough information before you as a basis to kick off the investigation? So if that is not the case, then you want to consider whether or not you need to go about doing a little bit more of a further fact-finding investigation.
The other thing, Joe, is very often complaints arrive in an incomplete form. Maybe they're an email, a long email sent at 3 a.m. at night that goes on for 200 paragraphs with all kinds of allegations in them. It's very, very, very common that you need to go back to the complainant and work out, well, what is it you're alleging? What was just blowing off steam? What are you actually saying here? Because if you don't have that scope really clearly outlined at the start of the investigation, essentially you are going to be going down rabbit holes throughout the next period of your life, trying to work out what am I trying to find. If the complainant can clarify and make certain what they have complained about, it gives you your scope to go and do your job.
Sounds like a recent true story. Yes,
that's right.
Once you've established that and you've gone about doing what Julian has just said, seeking clarification of any of the allegations that need to be clarified, the next thing you want to do is examining the rules, not the rules of the investigation, which we've already asked you to assess as a preliminary matter, but now you want to understand what is it that this person is alleging that a person or a group of persons has engaged in, or what conduct they've engaged in, and what breaches of what rules does this amount to? Is it a breach of the policy? Is it a breach of their contract? Is it a breach of a particular piece of legislation? There's a whole range of things you need to consider because, as Julian said earlier, getting it all right at the front end provides you with the platform to make sure the smooth running of the investigation is effected.
Without wanting to jump right to the end of the process, and hopefully not all investigations, or hopefully very few investigations get there, but in terms of working out what rules have been broken and conducting your investigation appropriately, the reason why we're interested in rules and policies and those specifics is because that's what the Fair Work Commission and other bodies like it will be interested in if things progress in a way where a claim is made and certain behaviours, conduct need to be assessed against the law. The question from a Fair Work Commission member will be, well, where is the policy? Where is the rule that this employee is you allege to have broken? If those haven't been clearly defined, if we haven't been looking for those things, what was the investigation for? There's many reasons to conduct an investigation, but one of them is to make whatever decision is made defensible should things progress to a more litigious state.
And Julian raises a really important point at this point, and it's central to any disciplinary process or any matter that will become before the Fair Work Commission at any given point, whether it's a bullying matter, a general protections matter, an unfair dismissal, but particularly in unfair dismissal matters. When you ask this question about whether or not a policy had been followed and what rules were put in place, that dovetails back into the requirement that the Commission will have, or at least an issue they'll need to be seen that's been covered off, and that is about procedural fairness. Has the person been afforded procedural fairness? If there's a policy in place, then the Commission and any other industrial tribunal hearing this, or even another tribunal in a discrimination matter, for example, they will expect you to comply with your own policies. And if you have deviated from your policy, then you might find that a breach of procedural fairness in that sense could alone result in some liability to the organisation. So don't just be focused on proving the conduct. Along the way, you've got to comply with the rules. That's really important. Proving the conduct's important as well. But
exactly right.
The rules are almost, well, in fact, they are as important as getting to the end, complying with the rules. And that's why we've talked about it already a bit. We'll talk about it again in the coming slides. Now, the other thing you want to do is you want to look at additional evidentiary lines of inquiry. And what you want to do is, before you get too far into it, but you also want to conduct this assessment throughout the investigation, are there other lines of inquiry I need to make? Do we need an expert at this point in time? If it's a graffiti case, do we need a handwriting expert? If it's an electronic communication issue, emails, internet, do we need a forensic expert to conduct an inquiry in that respect? If it's a surveillance issue, can we go and get that email ourselves without the need for a forensic expert? Can we go and get the camera surveillance that's available? Can we get the tracking surveillance that's available? And what's really important when you do that, we talked about the rules, is complying with the rules around gathering that evidence. So there's one main rule when we talk about evidence, and the Evidence Act around each of the states and territories and the Commonwealth Act talks about improperly or illegally obtained evidence. So when you're conducting an investigation, you don't want to obtain your evidence in an improper way or an illegal way. Now, when I say an illegal way, and we talk about electronic surveillance such as camera, computer, and tracking surveillance, and in fact, I should add voice recordings, listening devices, which is a touchy subject. Though it's really important that you have complied with the legislation in order to obtain that evidence, and it's important that your organisations have complied with the laws in that respect. Now, New South Wales and the ACT have very high standards of workplace surveillance regulation. In New South Wales, it's called the Workplace Surveillance Act 2005. It's a slightly differently named act in the ACT, and there are a smattering of laws around the other states and territories that apply to tracking surveillance, listening devices, camera surveillance, but we tend to focus on the New South Wales and ACT standards because they are the highest standards when it comes to those laws. There is also the Surveillance Devices Act in New South Wales, which applies to listening devices. And if you need to know what legislation applies to you, please feel free to reach out and we'll send you the details in your particular state and territory, because we regularly advise on a national basis to organisations. But it's really important, if you're obtaining that evidence, that you have complied with those laws. Just very briefly, when we talk about those laws, it's important you've complied with the notice requirements in the Act, you've complied with the requirement to have a policy, and you've complied with that policy, and that the individuals in the organisation that are your employees that you are investigating, or whose emails you are looking at, and internet activity, that they have read and understood, or at least they've had the policy communicated to them in a way that it's reasonable to assume that they have read and understood the policy. Once you've got that, you can get your hands on that evidence without the need for consent and all those other things you might ordinarily do absent compliance with the Workplace Surveillance Act. Now, the other thing you want to do is assess who the witnesses are. Now, obviously, you've got your complainant, they're your first witness. Anyone who is an accused is going to be a witness. And then you've got to consider, both at the front end and throughout the investigation, are there people I need to be speaking about? Now, this is another balancing act. You don't want to run off and chase every line of inquiry because, I mentioned earlier, resources and support. You're going to need a hell of a lot of resources and support. And in fact, if the investigation gets too big, it can become irrelevant in part, and you might be criticised for that at a later date. There's that.
I mean, that's the internal resourcing. There's also the fact that essentially if you shut down an entire team for the next week because I'm conducting interviews with all 60 people in the call centre or in the office or whatever, there isn't work being done in that team, and the investigation is hugely damaging and hugely disruptive to not only the complainant and not only the accused, but everyone else. You actually don't, you want to keep it as small as you can. But I think in terms of witnesses, you need to think laterally. We will get to the old conundrum, the old chestnut of, well, they just have a he said, she said, and therefore, what do I do about that? Things are more complicated. We can do better than just interviewing necessarily who you might think is the complainant and the person who's alleged to have done the action. You need to think laterally, but you also, as we will say, as we have said, it's a fine balance.
It is, Jules. And one of the things you also want to look at when you're planning the investigation is your methodology and your techniques. What techniques are you going to use throughout the investigation? What methodologies are you going to apply throughout the investigation? How are you going to conduct your interviews? Where are you going to conduct your interviews? Is there a particular investigation technique type that you're going to use? I know that some people from a safety perspective, might use, an ICAM type approach where it's incident cause analysis method. And some people don't like that investigation technique, but you really need to decide that at the front end, document it, and you document all of these things at the front end, because the plan will then largely plug into your report later on. Obviously, it'll require modification, but it will plug into your plan later on, and of course you'll be able to change your methodologies or techniques along the way if you need to, if they're necessitated by certain events occurring. And one of those might be, look, I've decided I will conduct recorded interviews. Now, one of the things I'll say about recorded interviews is that they are very good evidence, provided the recording is clear. They're very good evidence because it's difficult to dispute what was said later on if it's been recorded. The context might be arguable, but then that's up to you in terms of your interviewing techniques as to whether or not you have made clear exactly what you are asking, date, time, place, who was there, what exactly occurred, and whether or not you ask the necessary follow-up questions to make sure that the answer that's being given is put in the right context, in the context of your investigation.
The other aspect is some complainants, some witnesses, some accused will not give permission to be recorded. So you've got to be agile in terms of your methodology and your techniques. As Joe said, you're basically looking to balance how much is this going to take of time, of money, of effort against getting the best evidence that you possibly can to conduct your investigation. Some of the common things people can do is take a record, an audio record of an interview. Alternatively, you could prepare a statement for a witness that they can sign off on. That can be very time intensive, particularly if there are a number of witnesses. Equally, you can provide, you can ask written questions of a witness who can then provide a written response. I mean, all of these things have the one common trait, which is a record, a paper trail, an audio trail, something tangible to take out of the interview process, because that's what ultimately you're going to rely on as you plug it into your investigation report and as things proceed.
Yeah, just to tie off one last point, and I think it's implicit in what Julian's saying. It's really important that you get someone's signature on this stuff if it's a written document or an acknowledgement from them that is irrefutable as to that being their evidence. I have been involved in cases where a few things have happened. Firstly, a written account is not an accurate record of what occurred, and it's debated later on, or it is a representation made by someone else, like a lawyer or a union representative, which is later denied or disavowed by the witness as not being their evidence. So it's really important that it's direct evidence and it's acknowledged by the person, whatever technique you decide to implement. So we get to the point of kicking off the investigation, and we've got notifying the relevant people. This is a crucial point, and I think all of these points are crucial, but it is a really crucial point because your investigation can go off the rails at this point in time, and I'll tell you why. If you don't send a letter to the accused and the complainant and to the various witnesses that you know at that point in time, setting out very clearly what is going on and what is expected of them in terms of conduct, then later on, if they misconduct themselves by talking to each other, colluding as witnesses, or you might be suspicious they're colluding, sharing their evidence, thereby tainting their evidence, perhaps wording each other up as to what they should say in the investigation, it becomes difficult to discipline them later on. So it's really important that you set up at the front end the rules that they need to comply with. Now, if your policy says it, you might provide a copy of the policy and say, this is what we do in our investigations. If it doesn't, then the letter should set out the rules. The rules are confidentiality around the investigation and all matters relating to the investigation. They shouldn't speak to each other or anyone else in the organisation about it. If they need to speak to anyone, they need to come to you. When it comes to dealing with people who have been a complainant or any other witness, then there needs to be a warning in there about victimisation or adverse action being taken against those individuals. Now, if you lay that foundation, if there is misconduct at a later date where the individuals go off and speak to each other, that makes it much easier for you to deal with it as a disciplinary matter And often investigations are brought to a close very quickly when an accused turns around and victimises a complainant in connection with the investigation, because that matter becomes a priority over and above what's being alleged in the investigation. And what we find is there's a very quick disciplinary process relating to that behaviour, and the person leaves the employment very quickly.
The other aspect that's critical to get across in writing, as clear as day from the outset, is giving to the accused what they have alleged to have done. The key to this is really providing sufficient detail of the allegations to enable them to respond giving them a fair and reasonable opportunity to respond in a meaningful way. Equally, by sending the complaint or itemising the complaint to the complainant, at that point you can, so to speak, lock the complainant in to what the complaint is. Joe has talked about the investigations going off the rails when either witnesses or complainants or accused talk amongst each other or break the rules throughout. You also want to avoid the prospect of a complainant halfway through an investigation saying, well, actually, you're not, my complaint wasn't quite that. Did you investigate X, Y, and Z? And in the same way, the accused turning around, possibly at the moment of termination or sanction, saying, well, you never asked me about that. I never knew I had to respond to that. Or the classic one, well, I never knew that my job was seriously at risk because no one ever told me that if these allegations, if substantiated, may result in disciplinary action up to and including the termination of my employment. So it really sets it up. You get your ducks in a row and things start to flow in a way that's orderly and in a way that makes your job as an investigator far easier.
And I think just one final point on this, Jules, is that, you've talked about raising or setting out sufficient detail about the allegations. One of the questions we get asked regularly is, I want a copy of the complaint. Now, sometimes individuals ask that. It's often actually their lawyers or a union representative, a union official, requesting that document. A lot of organisations have a standard approach of just not providing the complaint. And I understand that, and in many circumstances you would not. But you do need to ask yourself the question, why wouldn't we? If it's appropriately written and there's no potential of compromising the complainant, then you should consider whether or not you provide the complaint. On the other hand, if from an evidentiary perspective, the accused, there's detail, I should say, in the complaint that the accused would be appraised of that might provide the accused with an opportunity to tailor their story, then you might withhold the complaint. But it is vital that you do what Julian said you do, and that is provide sufficient detail of the allegations to enable them to respond to the allegations that are being made against them.
As Joe said earlier on, part of it is finding out what happened, but the other part is affording procedural fairness to everyone so that when you get to the end of the investigation, it's something defensible that you can hang your hat on.
Yeah. Natural justice.
That's right.
So when we get to the point of interviewing these witnesses, there's sort of a range of things we look at. One of the things is location. Now, when we talk about locations, it is a really important question. It may not be appropriate to conduct that investigation in the workplace, particularly if it's a highly confidential investigation and if the workplace doesn't have sufficient facilities to be able to conduct a confidential investigation. So you start to look off-site. I would warn against generally going to places like McDonald's, cafes, hotel rooms. I know that this has happened because I've been involved in matters where people have been interviewed in hotel rooms, McDonald's and cafes, and it ends up being a complaint later down the track. There are circumstances where it can be appropriate.
Yeah, Joe, as an admission, I am an investigator who has previously interviewed people in cafes, in shopping centres, and it really is, I mean, it's a judgment call. Often the get out of jail free card with this is perhaps that's the witness's election. They say, well, it would actually, maybe they're off work, maybe it's not their day at work that day, and they say, well, really, I don't actually want to come in all the way to the city to come and meet with you. Can you come to the local supermarket and we'll have a discussion outside the cafe there. If you can hear the person, if you're recording the interview, that can present some real technical problems. But if you can hear the person, if you're taking good notes, if they've elected to do that, it can work, and it's obviously better than not interviewing them. Absolutely.
Another point is support person.
That's right.
So you should proactively, in my view, offer a support person. The statutory test for support people under the Fair Work Act is really whether or not a person has been denied the opportunity to have a support person. But I actually believe in proactively offering a support person. If the person chooses not to, then, well, that's a matter for them. Make sure you record that, and make sure you, not necessarily record it with a voice recorder, but you record it in writing by writing to the person, informing them or confirming that they have elected not to have a support person. An issue often arrives about who the support person might be. Look, they can be union organisers, they can be a lawyer if you really like. Lawyers always have some difficulty in being tainted if they're involved, because they may later want to represent the person and they might actually be a witness. So I would caution against lawyers. If lawyers on the line, I'd caution against you being a witness. But sometimes you can't avoid it. So support person is important. And then your interviewing techniques is really important as well. When you commence the investigation, have an interview protocol sitting there, setting out how things are going to proceed. And that might set out rules about the support person, when they can speak, when you require particular answers from the individual if they are accompanied by a representative support person. What you should also do is try and build some respectful professional rapport with the witness, whether it's the accused or not, but be careful not to overstep the boundaries of professionalism in that environment. If you do, it later may come back on you, particularly if the accused felt that you had built a friendly rapport and they felt that it was a betrayal of that relationship that had a degree of trust involved in it as well.
I think that's particularly right. I mean, as the interviewer and as the investigator, you've got to try and set the mood for an environment where someone is willing to speak. One of the things you can say, and you should say at the start of the interview, is, you know, if you need a break at any time, if you need a glass of water, if you need to go to the bathroom, if you just tell me and we'll do that. Setting the mood, making people comfortable in answering your questions can really facilitate meaningful answers for everyone. Not only the accused, who will often come to an interview extremely tense, extremely defensive, and jumping at shadows, paranoid about the questions that are being asked quite fairly, but also random witnesses, colleagues of someone who's had an allegation against them. They might not want to get involved. They might want to be on the side of the complainant, of the accused. You've got to set the mood where people want to talk, but I think Joe's exactly right. Being too friendly, trying to make a friend during an interview, it's not going to get you a good interview. It's not going to get you good facts. And to the extent that you have to make allegations against someone, or perhaps find someone that they weren't a witness of credit, it becomes complicated. So professional approach is good, but a professional approach which is not robotic, not scary, one that is interested in what someone has to say.
And I think there are a few themes coming out of the session today so far. The first one is following the rules. That's a consistent thing throughout the investigation, right from the start and all the way along. The second one's procedural fairness. And again, it's really important that you afford people procedural fairness. Now, one of the things you've got to be careful about, as Julian's just said, when building a rapport, is also not to be too cold. Because if you're too cold and too serious, I don't know if too serious is the right word, too stern with them, you might find that they're not forthcoming with any information, in which case you can have a witness who is non-responsive and unhelpful to your cause. And that the cause is just trying to find out what happened, really. And that's all they need to know. We're just here to try and find out what's happened. You've got to seek information through active listening. If you do find a witness that's not particularly responsive, have a whole range of open questions, ready open questions, ones that aren't too scary to start with, and move to your closed questions at the back end of the interview process. And finally, just a reminder, when you get to the end of that process, don't forget to get a signature on the record of interview. Now, it might not be available right there and then. You might need to email the person at a later date once it's been transcribed, if it's a recorded interview, or you might need to give them an opportunity to read it overnight or over a couple of days in order for them to apply any amendments that they think need to be made or provide additional information.
That's what I was going to say, Joe. I mean, the percentage of interviews that start at when you think they're going to start and finish when you think they're going to finish is very, very low. There's always something that comes out of these interviews which needs a follow-up either from you or from them. Occasionally people, I guess, reserve their position in relation to things. Sometimes that's not appropriate, but on other occasions they might want to find a particular document, or they might want to do something that they can't do at the point of the interview. It's just so important to follow these things up, and so that when you get to the end point, as Joe says, you've got to sign off, both literally and figuratively. This is your evidence, and we're going to hold you to that.
And that brings us back to procedural fairness again and natural justice. And if during those investigations or those interviews with witnesses additional matters arise, then it's important that you go back to an accused and put those matters to that accused, or even to key witnesses, where a key witness has a particular point that's in dispute by another witness. It's important to give consideration as to whether or not you need to go back to those key witnesses and put that particular point that's raised by another witness to them to get their response. It's not a case, as Julian said, of having a single interview that lasts for a couple of hours with each of these people and the investigation is over. It does require that additional consideration. Once we've done all that, we've gathered all our evidence and we've conducted all of our interviews, we then need to look at an analysis of the evidence. We need to mush it all together, pull it all apart, and start setting out what's going to go into your report, or at least the bare bones of what might end up in your report around the evidentiary analysis. You need to take into account what everyone has said about the issues and the allegations that are being levelled against an individual or a group of individuals, and then you need to work out what facts you can establish from that evidence. Whose evidence is going to be preferred? Is there objective evidence? Is there first-hand evidence? Is there circumstantial evidence that you need to take into account? I would caution against being flippant with circumstantial evidence. Circumstantial evidence can win you cases, but it can lose you cases as well. You know, we've had some high-profile criminal cases where circumstantial evidence has resulted in prosecutions that have been held against or in favour of the DPP and against the accused, and then only to be overturned on appeal. And the reason for that is that circumstantial evidence must be given due weight. It must be considered in all the context and circumstances of a particular person's version of events. A good example would be, you might have external, in fact, a good example of objective evidence that might overcome someone's evidence might be in circumstances where a person says they are in a particular location at one point in time, but electronic evidence suggests that they're somewhere else at a particular point in time. That might be a way where objective evidence will prevail over first-hand evidence. We're going to talk a little bit later about he said, she said, but it is really important that you go through a weighting exercise to work out which evidence prevails over the other evidence. And you've got to be careful not to be biased in the process. If you're biased in the process, it will come through. And if you put too much weight on a particular piece of evidence that is not compelling, but talks to your gut feel about the outcome of the investigation, then that will, if it's challenged later on legally, be put into the light of day, and unfortunately you might find you've got problems from a legal perspective.
I actually find often you can tell when you're writing the report as to whether your reasoning process in terms of assessment of particular parts of evidence actually stacks up. You'll make a finding about something, or you'll come to a preliminary view about something, and you'll have to, part of the process of doing an investigation report is actually putting that down. Often I find if I read that and I think, that actually is not that compelling, it's not that persuasive, I might have to revisit whether whether that's actually something that I could defend and whether that's actually what the evidence presents. The other critical thing, and this is something that's always a danger for anyone who watches a lot of courtroom TV, is the burden of proof in an investigation is the balance of probabilities. It's not beyond a reasonable doubt. It's not the case that the accused doesn't have to prove anything and it's all on the prosecution to prove that the accused definitely did what was done. It's the balance of probabilities, which is the more likely course of events. Is it more likely than not than this occurred? And that's actually a really different standard and should inform the way that you come to these decisions, because as we've mentioned a couple of times, the he said, she said approach, merely saying, well, he said, she said, I guess I can't do anything with this. It's not as simple on the balance of probabilities burden of proof. And I think we actually need to do more and be better as investigators to do something more with that kind of evidence.
We do, and there's an additional layer you need to consider with particular allegations that are made or particular circumstances that give rise to conduct that could be criminal in nature or very serious in nature that might have a result that has a catastrophic effect on a particular individual's livelihood. That particular standard, some people call it perhaps a higher standard, and there's a legal debate as to whether or not that's the case. But it's the Briginshaw standard. And it's Briginshaw and Briginshaw. It's a very old case. It's not important, the facts and circumstances of that case. But in that case, it was decided that when you look at the balance of probabilities involving very serious circumstances, including criminal allegations or allegations of a criminal nature, then you need to be comfortably satisfied as the investigator on the balance of probabilities that the conduct did occur. It's really important that you have regard to what an external individual, reasonable person on the street is going to think of your findings once they read that report. And that's the process Julian's just been talking about. When he sits down and reads a draft report or he writes something about a finding or an analysis of a piece of evidence, he turns his mind to whether or not a reasonable third party, such as a tribunal member at the Fair Work Commission, would look at this evidence and form the same view as you. The other thing you want to do at that point in time when you're conducting that analysis is again give consideration to whether or not there's further inquiries you need to make. Is there other information you need to gather? It might be that there are time pressures on your investigation. It might be there are cost pressures on your investigation. And they will sometimes give you a legitimate reason not to conduct those inquiries. But it's a balancing act. As I've said a number of times today, it's a balancing act. You need to balance that cost and that time delay against the importance of this evidence. It's
resisting the temptation to take the shortcut and just, well, I'll finish it, even though there's this lead that I've got, or we didn't quite address that, or we didn't actually put that to the accused. Once you put the full stop, once you press print on the investigation report, the door sometimes can close, and it can close in terms of the result, it can close very permanently for some employees.
It can. So we get to that point, once we've done our analysis, your report should be at least half written at this point in time. But you're now going to set about finalising your report, filling it out a little bit more. And what you really need to do is set out your methodology. What techniques did you deploy during the investigation? Set out the background, the relevant background to the investigation, and certainly the relevant background to the particular findings of fact that you have made or need to be made, and to the allegations that you ultimately find against the accused. Or, if you're finding the allegations did not occur, that they did not occur. You want to set out the allegations again in the report. The report needs to be a standalone document, in my view.
Yeah, well, as I always say, the report needs to speak for itself. It's someone picking it up, it's all wrapped up for them. Everything that they need to know to get basically to where you got to, or to explain why you got there, should be in the report. Reports can get very long, sometimes extremely long, but to the extent that you need to put the facts, you need to put the background, you need to put the methodology, you need to put the analysis in there. If 50 allegations have been made, you're going to have a very long report, because there is a process to get this on paper to make all of the pain, all of the time, all of the stress that you've undertaken to conduct this investigation worthwhile in the report, which is the result of everything.
And I think if you do have 50 allegations, Jules, then the most challenging thing about this investigation is going to be writing that report. You don't want to bore people to death with the investigation at the end. And that's why it's really important when we talk about analysis. We've got analysis in our list here. It is really important when you are making findings, particularly against someone, they are proven, then it's really important you provide an analysis. How did you get there? How did you take the facts and circumstances and land on this person did engage in this conduct? If it is a he said, she said situation, then you need to explain why you accepted one person's version of events over the other. There need to be reasons for the decision. You've got to set out your findings and provide reasons for your findings in that analysis as well. And then, of course, if you're asked to provide recommendations, and often internal investigators are asked to provide recommendations, particularly in relation to disciplinary conduct, then you need to make those recommendations as well. If you're an external investigator, it may not be appropriate to make a recommendation. If, for example, you're engaging a law firm to do the investigation like us, it's often not in disciplinary matters appropriate for us to make a recommendation about disciplinary action, because that's a separate matter for advice, and it's also a matter for the organisation to consider.
That's something, Joe, that I would be really careful about. At minimum, every investigation report needs to make findings, because the purpose of it was to find out what happened. To the extent that you haven't been asked to make recommendations, there may be a very good reason why you haven't been asked to make recommendations. So be really clear on what the scope of your instructions are, because if you go and make recommendations when you're not supposed to or you haven't been asked to, it actually can put your client in a sticky situation whereby they might not necessarily agree with your recommendations. They might have a million other factors to consider as to why the recommendations you've provided are not fit for purpose. So, in a nutshell, do what you're asked.
And sometimes not, but usually do what you're asked. So some of the errors you want to avoid in this process is making assumptions. So not putting all the allegations to the respondent and making assumptions about what a third party might think. It's important you set out that analysis in your report so that the reader, both the decision maker and also the third party tribunal member, theoretical third party tribunal member, comes to the same view as you based on the report there. So don't assume that they will make assumptions about a person's guilt or conduct. You need to set it out in the report. Another one is not following the rules. We've talked a lot about following the rules today. Some of the typical ones are ignoring your policy, forgetting or not checking what's in your enterprise agreement. A lot of people sort of negotiate their enterprise agreement and they forget about it for most of the year. It's really important you check your enterprise agreement. They often do have grievance procedures in them. They sometimes have investigation procedures. They've sometimes got provisions in there about giving a union organiser the right to represent someone. It's really important. And also ignoring new allegations is during an investigation is a common rule, common error that we find. If there are new allegations, consideration needs to be given as to whether or not they're hived off into a separate investigation, whether they can be dealt with as part of the facts and circumstances already provided for in that investigation, or whether or not you need to conduct further inquiries. You really need to consider that. In terms of delay, Jules, you want to talk to us about delay?
Yeah, look, in a lot of contexts, people make complaints because they're very upset about something. They feel unsafe, they're very unhappy. To the extent that investigations delay beyond a reasonable amount of time, not only is it bad for the complainant, it's bad for the team which is being investigated. It also can compromise, as we spoke about before, the actual sanctions that you might end up considering taking against the accused. So it's basically the response that we get often as lawyers. When do you need this by? Well, as soon as you can do it. You need to prioritise an important investigation and get it done, because to the extent that it drags on for a long time, it's going to compromise the whole point of what you're doing.
The other one, security of evidence, we've got up here on the screen. And what I mean by that is, in this day and age, we do find that we gather electronic evidence, and people like to take screenshots. A screenshot is helpful, but securing the integrity of the data itself is also important. So in this day and age, it's really important that you actually secure the data as well. So security of evidence is really important. And that means securing also other bits of evidence that you've got. I mean, it might involve a chair. If someone threw a chair at someone, then it might be really important to actually take that chair and effectively, as they say in the movies, bag it up and put it into an evidence locker somewhere or a makeshift evidence locker. But it's really important that you secure your evidence. The other one is documentation. Document everything. We've already talked about this, but make sure you document everything in your process. Document everything that occurred and make sure that the record is acknowledged by those individuals, as we've already said, when it comes to witnesses. And another one's poorly drafted reports. Sometimes I see reports where there is no analysis provided whatsoever, and the proper rationale for making the decision is not provided, and frankly, you may as well have not done the investigation.
That's absolutely right. I mean, the other aspect of a poorly drafted report is not conveying all of the work that you've actually put in to get to the point. If you haven't created the record and you don't put it in the report and you interviewed this person, you got this information, all of your work comes to naught because, as Joe says, a poorly drafted report occasionally, it's not worth the paper it's written on.
Then you get to the point of passing your judgment. You've got to make sure that as an organisation you are notifying the respondent, the complainant, and sometimes the witnesses. Sometimes staff need to be notified if it's a well-known matter. Then maybe there needs to be a staff-wide communication. You would avoid that if it's a confidential investigation. In relation to the report, just remember, generally speaking, subject to what your policies say or your enterprise agreement and any other rule that you've got in place, you may have to disclose the investigation report, but generally you don't. And generally you wouldn't unless you'd consider that you need to. But I always like to think, well, why not? If the circumstances are appropriate, there's no reason why you wouldn't then provide the report. But there's no rule that you generally have to provide the report. And then the all-important follow-through, that is making sure where there is disciplinary action to be implemented, you implement it. Making sure where there are broader organisational recommendations that you actually implement those recommendations and follow through.
The other aspect is a lot of investigations don't make out the complaint. And you need to be prepared for the fact that there will be some complainants who will be disappointed with the outcome. There will be some complainants who are unsatisfied with the outcome. There will be some complainants that are so upset by the outcome that they want a new job and they can't stand working in the organisation anymore. So being ahead of the game as to what's going to happen after you issue the outcome is really, really important. And that's not always about, well, we've decided to terminate this employee and we're going to have the meeting and he or she will be gone after tomorrow. Often it's far more complicated than that, and the whole investigation process can take a toll on people, which you need to be aware of.
Absolutely. Now, from a PR perspective, reputation, it's really important. Just putting legal liability to the side, reputation is a risk. Irrespective of legal tests these days, the court of public opinion is a harsh one and often a more costly one than our courts and tribunals themselves. So it's really important that we give consideration as to whether or not, in very serious matters, you need to get a PR specialist. You might consider doing that. Now, obviously, that's a costly exercise, but it's essential in certain circumstances. Where you do have a poorly executed investigation, it can spill into the public arena, and then you need to decide what's the public narrative about this and how do we manage that. Another issue is, and this is where an investigation usually goes public, what if a complainant goes rogue? So you need to think about that at the front end. As Julian said when we were talking about setting up your investigation, if you get all this stuff right and you do everything we've said today, then you're in the best possible position from a public perception perspective to manage that issue. Some FAQs.
Maybe I'll ask these of
Sure.
you, Joe. So the complainants union says they will be representing the accused and want to speak on his behalf. They can't do that, can they?
Yeah, I think they can, to a degree.
Right.
Now,
I was worried.
One of the things I want you to do is not get too focused on the whole, they're only a support person business. You might even have a policy that says you are just a support person, do as you are told. The first thing is, does the enterprise agreement entitle them to representation? And we've seen this happen before, where a breach of an enterprise agreement is inadvertently occurred because the individual is being represented by their union and they're told they can't. That's a breach of the EA, so be careful about that. But if you can agree to it, just agree to it. If the union can come along and have something to say, so long as the witness is actually giving the crucial answers themselves, then I'm pretty comfortable with that. What often happens is that an individual is objected to on the basis that they're a union representative or they're a lawyer, and that becomes a sideshow, and the whole investigation goes off the rails.
Well, it becomes combative. It becomes a courtroom instead of an interview. Ultimately, you're interested in what the person has to say. So what their union has to say might be relevant, it might not be, but you want to get the information out of these people. And if that involves listening to someone from the union, that's what it involves. Joe, can I ask a second question? It's his word against hers, so I'm not able to reach an outcome, am I? This is the he said, she said.
Yeah, look, I have to say, in my experience, it can happen, but it's rare. You often can come to a view that one person's evidence is preferred over the other. Now, it may not be in totality, and you might find that both of them are telling a few porkies, but at the end of the day, it is not an automatic situation where that person gives a completely different version of events to this person, therefore they cancel each other out and you're at a zero base. It is very rare that that occurs.
Can I ask you, Joe, a number of witnesses will not agree to participate, so I can't advance the investigation in that regard, can I?
There's two things to say about that. The first one is if the witnesses are external third parties, it might be the case that their evidence needs to be, the investigation needs to be proceeded without their evidence. That will happen. The second one is where you've got an employee who is a witness, then employees need to follow reasonable directions of their employer. If they are a witness, then they can be required to come along, they can be required to answer questions, and they are required to answer them honestly. It's the
witnesses who won't talk. If they're your own employees, you're saying they kind of have to talk.
Absolutely, absolutely. So that really brings us to the end, Jules. We have up here on the slide here the importance of getting it right from an investigation perspective. We run training around this, so it's a lot more in depth than today, and we drill right down into all of the issues today. We talk about some cases, we talk about some of the cases we've had to deal with. It's a full day training course. We do in-house, or we have a general ABLA venues, and we do this in Brisbane, Newcastle and Sydney, but we also do it in some of our regional areas where we service clients, and Victoria and Adelaide from time to time if the demand provides. You can see here on the screen we've got a training session on the 7th of May if you're interested in Brisbane, and Sydney we've got one on the 30th of May. So if you're interested in that, please take that email address, that web address that we've got up there, ablawyers.com.au/training, and you can register there for it. If you want tailored in-house training, then call 1300 565 846 and ask to speak to marketing, and they will talk to you about in-house training. Julian, thank you very much today for participating, mate.
Absolute pleasure, Joe.
Have a great day, everyone.